At 10:30 yesterday morning, the Supreme Court of the United States issued an order so brief that it barely registered as breaking news. 2 words. No explanation, no dissent, no elaboration. Just a denial that quietly eliminated the final procedural barrier standing between prosecutors and a key witness. In federal law, silence like that is not neutral. When the court rejects an emergency application without comment, it signals something far more decisive than a routine denial. It means the argument failed at the threshold. Not because it was controversial, but because it was legally unviable. That matters because the application was not abstract. It was designed to stop testimony before it happened, and it failed completely. The timing of that failure is what transforms this from a procedural footnote into a legal inflection point. 72 hours earlier, a cooperation document was filed with federal prosecutors. A proffer agreement. A written outline of evidence a witness is prepared to provide, paired with a request for immunity consideration. This was not compelled testimony. It was voluntary, and it changed everything. Before that filing, the case moved through familiar terrain. Motions, privilege claims, delay strategies, procedural appeals. After it, those options narrowed sharply. The Supreme Court's denial didn't create that shift. It confirmed it. To understand why, you have to understand what a proffer actually is. In plain terms, it is a preview. A witness says, "This is what I know, this is what I can prove, and this is what I will say under oath." Prosecutors evaluate that offer before deciding whether immunity is appropriate. If the information is redundant, cooperation goes nowhere. If it fills gaps, corroborates other testimony, or connects documents to intent, the leverage changes instantly. Here, the proffer did not arrive in isolation. It landed in a case already built on financial records, sworn statements from bankers, and testimony from accountants. What prosecutors lacked was not volume. It was proximity. Someone inside the decision-making circle who could place knowledge, timing, and intent in the same frame. That is what makes this moment different. The cooperation document outlines 3 categories of evidence. First, financial documentation establishing awareness of disputed asset valuations. Second, communications referencing those valuations before loan applications were submitted. Third, witness testimony corroborating prior grand jury statements. None of this is speculative. Each category is evidentiary. But the most consequential aspect of the proffer is not what is being offered. It is what has been relinquished. Spousal privilege. In federal court, spousal privilege is often misunderstood. It is not an impenetrable shield. It belongs to the witness spouse, not the defendant, and it can be waived voluntarily. That principle has been settled law for decades. When a spouse chooses to testify, the defendant cannot block it. The emergency appeal asked the Supreme Court to create an exception, not based on law, but on identity. The court refused, unanimously. That refusal matters because it eliminates the final delay mechanism available in this posture. There are no further appeals that can stop the testimony from being heard. No stays, no injunctions, no procedural detours left to take. Which brings us back to the timeline. Monday afternoon, the proffer is filed. Tuesday, an emergency appeal appears. Wednesday, the court dockets the matter but issues no stay. And at 10:30 yesterday morning, the court closes the door. That sequence does not suggest coincidence. It suggests anticipation. Defense teams do not file Supreme Court applications in 24 hours unless they know what is coming. And courts do not respond this decisively unless the law is settled. Now the question becomes procedural rather than speculative. When testimony becomes inevitable, prosecutors must decide how to use it. There are only 2 paths: incorporation or expansion. Either the testimony strengthens existing charges or it supports new ones. Both paths carry consequences. If the testimony confirms knowledge and intent behind financial representations already charged, it solidifies the case without changing its scope. If it introduces coordinated action, agreement, or concealment previously uncharged, it opens the door to a superseding indictment. And timing matters here. Trial schedules compress once appeals are exhausted. Grand juries reconvene quickly when new evidence clears privilege barriers. Decisions that once took months now take weeks. The system is designed this way for a reason. Federal procedure tolerates delay up to the point where evidence becomes fixed. Once testimony is admissible and unavoidable, the process accelerates. Not because of politics, because uncertainty has been removed. What makes this moment particularly consequential is not the identity of the witness or the defendant. It is the convergence of three institutions acting in sequence: prosecutors accepting a proffer, defense exhausting appeals, and the Supreme Court declining to intervene. That alignment does not happen often, and when it does, it usually marks the end of maneuvering and the beginning of consequence. The testimony has not yet been heard publicly. The grand jury has not yet spoken. No verdict has been rendered. But one thing is already clear: the legal terrain has changed. And once it does, there is no path back to where the case started. Once the Supreme Court denied the application, the question stopped being whether the testimony could be blocked and became how quickly it would be used. In federal prosecutions, that shift is decisive. It signals that strategy has given way to procedure. Grand juries do not wait indefinitely. When a witness clears privilege barriers, prosecutors move with intent. Schedules tighten. Witness lists expand. Evidence that once sat in parallel files gets consolidated into a single narrative. That is where this case now stands. The cooperation outlined in the proffer does not operate in a vacuum. It interacts with existing evidence already under oath. Bank executives have testified about loan submissions. Accountants have testified about valuation discrepancies. Appraisers have testified about pressure. What prosecutors gain now is context that binds those strands together. In white-collar cases, that binding function is often decisive. Jurors do not struggle to understand documents. They struggle to understand motivation. Why numbers changed. Why warnings were ignored. Why false statements persisted across multiple transactions. When testimony explains those choices from inside the room where decisions were made, the evidentiary weight multiplies. That is why spousal cooperation is treated carefully but seriously in federal court. Not because of sentiment, but because of access. A spouse present during financial planning meetings, document reviews, and lender discussions occupies a vantage point few others do. When that vantage point becomes part of the record, it changes how the story can be told. The defense understands this, which is why the emergency appeal was filed, which is why it failed. With privilege waived and appellate avenues closed, the next procedural steps become predictable. The grand jury hears the testimony. Prosecutors evaluate whether the evidence alters charge structure. If it does, they seek authorization for additional counts. If it does not, they integrate the testimony into the existing case. Either way, the leverage shifts. This is not about sensationalism. It is about exposure. Each additional corroborated fact reduces the defense's ability to argue misunderstanding, delegation, or lack of knowledge. Those defenses rely on distance. Cooperation collapses that distance. What follows now is a period of intense legal calibration. Prosecutors will weigh the value of expansion against the efficiency of consolidation. Judges will enforce timelines with fewer accommodations. Defense filings will reveal priorities by what they attempt to exclude rather than what they explain. That is how seasoned observers read cases at this stage. The public may focus on personalities. The court will focus on elements: knowledge, intent, agreement, execution. Those are not abstract concepts. They are boxes that must be checked. Cooperation helps check them. The Supreme Court's role here was not to decide guilt or innocence. It was to decide whether testimony could be suppressed on privilege grounds. It declined to intervene because the law did not support suppression. That decision now cascades downward through the system. Trial courts respond. Grand juries respond. Strategy recalibrates. What makes this moment particularly instructive is how little drama it required. No oral arguments, no written opinion, no televised announcement. Just a procedural outcome that carries enormous weight. This is how accountability often arrives. Quietly, through filings and orders rather than speeches. There is still process ahead. Motions will be filed. Evidence will be challenged. Judges will rule. And if the case proceeds to trial, jurors will decide. None of that has been bypassed. But the terrain is no longer fluid. The cooperation is real. The privilege is waived. The appeals are exhausted. From this point forward, every decision is constrained by those facts. That is why this moment matters. Not because of what has already been said under oath, but because of what can no longer be kept out of the record. The system has reached the point where evidence, not delay, determines direction. And once that point is crossed, outcomes are shaped by law rather than leverage. That is where this case now lives. And that is why what happened at 10:30 yesterday morning will be remembered long after the headlines fade.